The time's come to expand into Canada. You're a US-based franchisor. You want to start selling franchises in Canada. We're going to discuss every step you need to know about to get up and running in Canada in 5 and 6 weeks. Today, we're going to talk all about Canada, expansion up north with our Canadian brothers and sisters, and there's no better person than franchise attorney Frank Robinson from Cassels up in Canada. And Frank, I appreciate you spending some time today.
Absolutely. Thanks for having me here. I'm excited about it. I listened to a lot of podcasts. My first time participating on one. So again, thanks for having me. I look forward to our conversation today.
Yeah, no. So my staff, they warned me. They said, Charles, try not to be boring. And then when I'm not boring, it's just stupid jokes, which would be about maple syrup and hockey and everything else in Canada. But, you know, the thing that comes up so often, and we represent emerging brands, franchisors here in the United States, Canada is such a natural market for U.S. brands to expand into. And then for a separate conversation, for Canadian brands expanding into the U.S. And so the questions come up so often, Frank, and you're an expert up there. So I thought this would be a great forum for us to develop some basics of what franchise law, what are the building blocks up there in Canada, and then we could dive into really a lot of questions I know U.S.-based franchisors have.
Absolutely. That sounds like a great plan. And you're right about it. I often am on the other end of those jokes about hockey and maple syrup and a lot of snow. We got a lot of that, especially here in January. There's a lot of snow here in Toronto where I'm located. We also have a lot of franchising. I don't know if your viewers know this, but Canada is actually is the second biggest market for franchising in the world, right behind you guys, our neighbor to the south. So when you mention Canada being a natural destination for franchisors in the United States that are looking to go international, Canada is obviously, an easy target. We're right next door. We share a common border. Actually, I'm going to get the statistic wrong, but I tell you a vast majority, maybe 80, 90% of Canadians live within 100 miles of the U.S. border. So, not only are we neighbors, we're your next door neighbor. We share that common border, very similar in terms of our commercial interests, the things that get us excited, the brands we're familiar with, the types of services and products that, are the things that we're going to want to buy and participate in. So, and not only that, there's the American appeal. So when we travel to the United States, we see the new shiny brands and the things we're excited about down there. When they show up here inside the Canadian borders, we're excited about visiting them and shopping at those locations. So, all of that really is the beginning of, the story of how franchising succeeds in Canada, but there's obviously a lot of detail beyond that, which we can dig into as we go through our discussion here today.
You mentioned, I didn't even realize Canada is the second largest market. Before we dive into what type of activity are you seeing where franchisors really need to enter the Canadian market or have questions about entering the Canadian market?
Well, I mean, that's a good question for me. As much as I'm a Canadian franchise attorney, I'd say certainly a majority of my clients, and sometimes even a strong majority, up to 60, 70% of my clients are US-based franchise systems that are expanding into or are already in Canada and looking to grow even further into Canada and then beyond Canada to domestic markets. So you're asking me that questions about American brands and what they need to do and what they need to think about in Canada. That's what I do every day of the week. So certainly can help you and your viewers understand that. I think your question was more about why would Canada be a market? Why is that a destination? Of course we share that common border. There's a lot of similarities between the markets in the two countries in terms of the products and services that are attractive and interesting to consumers here. Canadians are familiar from the media that we see that spills over the border in terms of the TV and movies that we watch with the brands and the things that are exciting and novel in the United States. And we're always looking to find the new exciting brand to shop at and to experience through that, and also through our travels. A lot of Canadians spend a lot of time, particularly in the winter, in the southern states. And so, there's a lot of familiarity with the franchise brands and the retail brands that exist in the United States, and always a lot of excitement when they seem to show up here in the Canadian market. And that's obviously the expansion of new and exciting brands, but they're the long-standing traditional brands from the U.S. that have been in Canada for a long time.
So Frank, we're U.S.-based franchisor. They come to me like, Charles, what do we have to do to expand in Canada? If we're not ready now, maybe are there some steps we should be taking? Before I even get into that conversation with those franchisors, with our clients, right? They all understand here in the United States, we have federal, state franchise laws. We have our franchise disclosure document. We want trademarks to be registered with the United States Patent and Trademark Office. From a macro level, what would be just the basic blueprint of what US-based franchisors need to know about entering the Canadian market, and in particular, developing a franchise offering there?
Sure, that's a great question. And there's a lot there, and we can kind of unpack it, but maybe it makes sense to start at the top. And what I mean by that is at the federal level. So unlike in the United States, we do not have a federal franchising statute in Canada. Okay, so what we have instead are 10 provinces, and 6 of those 10 provinces have franchise statutes. And each one of those will apply depending on which province you are operating or offering franchises in. So there's nothing at the top. It depends on where you are franchising, depending on which province you're in. That's the franchise law that's going to govern. Most of those franchise laws are very similar. I'd say across the board, 80 to 90% of them are pretty much carbon copies of one another. They differ in the margins and some little small aspects of them that relate to what needs to go into a disclosure document pursuant to the laws of those particular provinces. But for the most part, and for the purpose of this conversation, they're effectively the same. And they are also very similar to the US franchise laws. So when you have a disclosure document that's been prepared pursuant to the laws of the United States, under the FTC rules, those are going to be very similar in their format and their content to a Canadian disclosure document. Again, don't take that as the end of the conversation. There are definitely differences, and both substantively and in terms of the form, but the rules are very similar in Canada. Before you sell a franchise to a franchisee in one of those 6 provinces, you have to provide a disclosure document, and you have to wait 14 days before you sign any agreement or take any money from that prospect. One important difference that is a good one for Canada, at least, is that we don't have any filing or registration requirements in this country. So there's no regulatory oversight. There's no administrative body that needs to be consulted with or provide their approval with before you can sell a franchise. What will happen is a franchise brand and their counsel will sit together and prepare a disclosure document. As soon as those individuals believe that document complies with the law, the business providing its insight and its information that it's comfortable with about the business, and counsel deciding that information satisfies the standards of the law, that document can be used the very next day to sell and offer franchises in Canada. You asked before, and maybe I'm jumping the gun or providing too much information all at once, but you asked what were the building blocks to, for any franchisor that's looking to come into Canada. If you want, I can start down that path too.
Yeah, no. So let's do that, because I think franchisors would love this. And before we even get to that, right? So no federal law. You have different provinces. We don't have registration, which franchisors would love, right? So we could get up and running. Before we get into the building blocks, one issue that comes up so often, or I sort of want to get a sneak peek here and just discuss 2 things, right? So now I know we could get up and running in Canada, no registration. Let's convert our FDD. Next question is, at a macro level, what are we doing with franchisor financial statements, right? Audited, not audited? Are we setting up a subsidiary company in Canada, right? And now I know I'm jumping the gun, but this is what our clients are asking about right out of the gate. Yeah. So you know how it comes in too, right? And if you're a franchisor watching it, it's not like it's, hey, Charles, hey, Frank, 6 months from now, I want to do a deal. It's, hey, Charles, hey, Frank, we want to close a deal in next month. And how do we make it happen in Canada?
That certainly happens, but it happens in the other way as well. And so what I was going to mention to you, and this is nothing I've made up, we've probably heard this before many times, but there's a push or a pull, right? Oftentimes our clients, and this is probably closer to what you just mentioned, are pulled into Canada, meaning,
Yep.
they have a transaction. Someone, maybe, as I said before, some Canadian entrepreneur or business person saw, a new flashy brand when they were traveling in Florida for their Christmas vacation. Then they call the franchisor and say, "I want to bring you to Canada." Franchisor is enamored by that. They're excited about a new transaction, a new market, so they're being pulled by that opportunity into Canada. I certainly have clients, and that happens a lot, doing that and following that path. But there's definitely many that push into Canada. By that I mean, their board or their company decides we've maximized the market in the United States, or the areas that we want to be in. We find there's an opportunity in Canada. Let's get our ducks in a row and start attacking the Canadian market. We don't yet have prospects there or a pipeline, but we want to build one out because we think that's a new and exciting market for Canada. So those create different opportunities. They create different problems or issues to tackle. But at the end of the day, you have to come into Canada the same way by attacking and dealing with those building blocks we talked about before. But if you want to address the specifics you mentioned, or the questions I know your clients are asking about, and by all means, let's give the clients what they want. They're asking about financial statements, or they're asking about corporate structuring. Those are great questions, because those are threshold or initial questions that need to be addressed before you get into actually preparing documentation. So, what I would say to you is, for the most part, the clients that I see coming into Canada, and I'd say for the most part, I'd say mostly 50, 60% of them, 60, 70% of them will continue to use their US franchising entity when they enter into Canada. And by doing that, they're entitled to continue to use their financial statements that they have in the United States, so long as they meet certain conditions. So our statutes permit the use of a foreign financial statement as long as they are at least equivalent to Canadian accounting standards, or otherwise meet international standards that are set out in our rules. I don't need to get into the sort of gory details of all that right now, but it is enough to say that if you have, let's say, for example, a U.S. LLC entity that's your franchisor in the United States, you can certainly use that in Canada. And in most cases, you can use the audited statements that you have from your U.S. FTD in Canada. Don't have to do anything new. That having been said, the advice often and almost always given to clients is you should get proper tax advice before you push or are pulled into Canada. Because once you enter into a franchise agreement that goes over the border, meaning from a U.S. LLC entity to a Canadian resident franchisee, you have a contract that's between an American and a Canadian, with money that's now flowing over the border, and that's now subject to international tax issues, including withholding tax and other things like that. That can actually have an impact on cash flows and add a whole bunch of paper and tax compliance for both parties. So depending on that analysis, you may end up with a different entity that's your franchisor. Some clients, I mentioned the majority probably don't do this. So that the balance of that is that some, on the minority, for the most part, will form a new entity to be the franchisor in Canada. That might be a Canadian subsidiary. So the LLC, for instance, might form a subsidiary that's a Canadian entity incorporated in one of the provinces, or maybe a federal corporation, or maybe in very rare cases, they'll form a new U.S. subsidiary that will directly franchise into Canada. The best answer I can give.
Yeah, Frank, if we were polling brands entering Canada, what percent franchise directly in their US-based franchise company versus setting up a Canadian subsidiary? Yeah. And we know this is unofficial, but generally, what do you say?
It's a good question, because I'm asked that a lot. Like, the question is, well, what do most people do? When I pose the question, how are you going to do this? What do most people do? And most of them are doing it using their US entity. I'd say, to answer your question specifically, between 50 and 75% of them will use a U.S. entity. They continue to use their entity. And what I like to do for clients is suggest to them that it's possible to change their mind later. So we'll create documentation that allows for flexibility in the future. And if in the case of a corporate restructure or something of that nature, that we can move assets and contracts around in case you decide you want to do it differently later. there'll be a tax consequence to changing your mind later if you have to move assets around, but at least it allows the flexibility to change your mind if you have to do that.
And I like that, because usually it's, especially for emerging brands, right? If you're being pulled into Canada, it's a good way to test out the market and get a foundation set. Typically, we would see, usually there's accountants too that can sort of adopt or reinterpret US financial statements to conform to Canadian standards and things like. So the process isn't overly complex on that end. And then, Frank, in terms of trademarks, what are the issues that you see for US based brands? Like the thing that keeps me up at night, or I'm always concerned, thriving US brand hasn't protected its IP in Canada. So my question is, for a thriving US franchise brand that may not have plans to go into Canada, what do you recommend they do with their IP? Franchise brands that are entering Canada, what's involved? And generally, what do you recommend from a best practices standpoint?
Yeah, I mean, that's worthy of keeping you up at night, or at least those who own important and well-known brands up at night, because that's a real issue. There's some well-known stories of US brands having not taken any steps to protect their trademarks in Canada, announcing that they're coming to Canada, only to find later that somebody else has squatted on or legitimately registered the same or confusingly similar marks in Canada, and preventing them from coming into Canada using the brand and logos and branding that they want. There's an example of that, of course, for Burger King in Australia. If Burger King is called, I think it's called Hungry Jack's or something like that in Australia for that reason. And there's very similar situations in Canada. So the best advice is obviously to protect your trademarks as broadly and as early as possible in the international markets in which you may one day want to go. That certainly should include Canada being your next door neighbor, but using Australia again as an example, or other international markets where that's important, or where you see growth. And that may not only be for you as an emerging franchisor. One of the things I like to tell emerging franchisors is, if you're going to be bought up by a private equity group or someone like that, their MO always is to buy it and grow it. And if you can say to them, look, we've reserved our trademarks in other markets, the path is open for growth. And that may be seen as a true benefit, as opposed to a big black mark on your brand if you tell them, or they determine on their own, that Canada's blocked because the trademarks aren't available there. So even if you're not going to expand today, tomorrow, or any time in the future, having that as an asset and as a path that's available to you or a future owner of your brand adds tremendous growth. And the cost or value, I should say, and the cost to get a trademark in Canada is not at all onerous. It's a few $1,000s to do a trademark search, which would identify possible issues with your application before you make it, and then a couple $1,000s or less to actually file it, pay for government fees and some lawyer time to prepare an application. There are some domestic markets, like I think Mexico, for instance, where you must have an application or even a registration before you can offer franchises in Canada. Again, not the case in Canada. You can offer a franchise on the basis of having no trademark rights whatsoever. You'll have to disclose that in your FDD, and that may prevent you from being able to easily sell franchises if your IP has a whole bunch of problems associated with it. But it's not a legal requirement that you have an application or registration made. But it obviously it's well advised, because you can't really grow a franchise system if you don't have well protected trademarks and can't assure your franchisees that they're not going to get into hot water if they end up using your marks and then get a trademark infringement or something like that. Once they open their doors.
Frank, if I'm a US based entity, I'm not operating in Canada yet. Is it easy for me to get trademark registration? Is there like an intent to use application here in the United States? How would I go about, is there complexity there with corporate structures or taxing authorities in Canada, or can I, as a U.S. company, just file in Canada?
No, you absolutely can. We have plenty of applicants and registrants that are, entities or individuals that are located across this globe. So that doesn't prevent an international owner of trademarks in Canada. You just have to follow the process of going through the application. And there are different bases upon which you can make application to your question. We actually are just getting towards, the initial stages of having amended our Trademarks Act in the last 1 or 2 years to change the way the application process is made. It was historically done in a different way. So, there are changes that have been rolled out in the last couple of years. They do relate to things around the question you mentioned about intent to use and things of that. It's a little bit easier to make applications now in some regards than it was before. So we actually do a lot of IP work for our for our franchise clients. It kind of goes part and parcel with the franchise work that we do, regularly advising clients on availability, on risks associated with using trademarks, on licensing them, of course, the way they are disclosed in disclosure documents and all that sort of thing. So to me, kind of tying together some of the concept we talked about, the corporate structure and the IP, those are, as I call them, threshold or sort of foundational concepts that are things that should be done really immediately and early on in the process to get you in a good place and put your feet underneath you and get you sturdy enough to start on the next couple of steps after that, which I'm sure you're going to ask me about in terms of preparing documents and actually getting, into the nitty-gritty of offering materials.
So threshold items, right? Corporate structure, IP, right? All foundational, and you provided a lot of clarity. There's a clear pathway to do that, and we could get set up. Before we dive into preparing the disclosures and whatnot, just want to peek into that a little. How do you guys in Canada, how do you handle financial performance representations? Do you have an equivalent to our item 19, and what's the theory behind your financial performance reps up there?
Right. Okay. Great question. It's a great question. And like in the United States, I wouldn't call it a minefield, but it's tricky. One of the trickier things is we don't have guidance from something like an FTC because we're not regulated in the same way. We don't have a filing or registration requirement. We don't have to go through a regulatory body. The only sort of guidance we have is a guidance from the courts. We don't have any interpretive manuals. We don't have anyone we can consult in the government to ask us how things should be interpreted. And I know from doing so much work with U.S. brands and having relationships with U.S. attorneys, they spend a lot of time navigating those FPRs with the regulators. We don't have that here. We have a very basic standard, which is that the financial performance representation. So maybe to answer your question more directly and in the order you asked me, yes, we do have something that's similar to item 19. They're not called item 19, but it's the same idea that we call them financial performance representations or FPRs. They're voluntary. You don't have to make them. But if you do make them, then you have to do them in a very specific way and follow some of the rules I'll mention in a minute. As much as they're voluntary, I think we both know, especially for emerging brands, that's one of the first questions franchisees are going to ask. And if you think that's important enough that you need to discuss by FPRs to sell franchises, and many brands do, then you have to be realistic about it and put it in your disclosure document, and your oral or spoken disclosures and the way you sell franchises have to be consistent with the written document, just like they do in the United States. So then if you're in a situation where you think, I'm a new brand to Canada, I need to make FPRs or I need to make financial performance representations to make my name known and sell franchises in Canada, then you're going to have to do it. It's almost not voluntary, or it's voluntary in the sense that, the law says so. But as a commercial matter, as a matter of reality, you're going to have to put them in your document. Now we're in a situation where you may be a U.S. brand and you have no experience in Canada. You may also be an emerging brand in the United States. So you're only regional. You may only have a handful of locations. The question then becomes is it reasonable or not? And that's a legal standard. Is it reasonable to put financial performance representation for maybe a short period of time from a regional or small area in the United States into a Canadian disclosure document? And that can be a tricky analysis because it may or may not be, depending on the types of information you have on the reliability of the information that you have, on the scope and depth of the information that you have, on how similar the Canadian and United States markets may be in terms of the prospect that the results may be at least somewhere in the same vicinity or related to one another. We do a lot of work with clients to contextualize the information from the US FDD if we're going to put it into the Canadian document. That may be to include disclaimers, to identify how the Canadian and US responses or performance may differ, just so that the reader has a very strong idea about what it is they're reading and can take that information and extrapolate it and do their own homework based on the information that's given to them, and have enough of that context and understanding of what they're reading to make an informed decision about it. Every one of those decisions is made sort of on a case-by-case basis, depending on how much tolerance for risk the client has, how much they think they need to include this information, how reliable we think the information is, how reasonable ultimately we think it is to put it into the Canadian document. So taking that back a couple of steps, yes, we have item 19 or something similar to that in Canada. You can use your item 19 in Canada if it's reliable and reasonable, and we do that quite often.
Just generally, the Canadian market in general, what percentage of franchisors are relying on financial performance reps?
That's such a great question. And I get this a lot. I also get the question, can I get a copy of X, Y, and Z franchise disclosure document, or do you have information about that? So again, the sort of the theme here, because we don't have filing or regulatory oversight, there's no central place to find those. They're not public information. It's not public information. So there are private companies that collect and collate these things, and they provide their own analysis and summaries of things. So, those are available out there, and they can be purchased to some extent. My view, though, is that as time goes on, it's more and more common to see those to see an item 19. Especially for emerging brands, because it becomes a commercial imperative that they're included in the document to actually sell franchises. And then the same thing happens that, over time, when you become sophisticated and larger scale, you have robust, reliable, very long-standing history of collecting this information. That becomes information that's really easy to disclose. So when you're a big traditional franchisor, that information is available. It's reliable. It's usually pretty it's something you want to share because you've reached that level of success. So those are the sort of two sides of the spectrum. The emerging franchisor feels like it needs to do that to sell franchises. The franchisor on the other end of the spectrum, that's traditional and large scale, has already got that information and can rely on it easily. And somewhere in between those is the rest of them that decide on what they're going to do in the middle.
Right. If you can recap, and I know we didn't go into the detail in terms of the documents, but franchisors entering the Canadian market, if you could just recap for us, hey, these are best practices, the steps you're going to follow.
Yeah.
And then the question I'm going to have after we get done with that is, like, what are the pitfalls you see? Like, where are the legal landmines happening where you're like, I wish they didn't, that all could have been avoided.
Right.
But let's hit the basics. If someone's watching this now, here's the checklist items we need to lock down as we enter a Canadian market.
So I like to keep things simple as much as possible, and I think clients appreciate that because you can feel like your head's spinning a little bit if you're trying to go into a whole new country. But I like to.
And Frank, by the way, I've had calls where, like, we have a client, years ago entering the Canadian market. And look, I'm not being negative because I think accountants could be worse than lawyers. If I tell you I got on the call and all the client wanted to do is sell a franchise in Canada, and there were teams of accountants on talking about offshore companies, I'm like, way complex. But I appreciate you driving this home. We're entering the market. What are we what do we need to lock down entering the Canadian market?
Yeah, I mean, you can make it as sophisticated and complicated as you want, and if you allow that to happen and you ask for that type of advice, that's the type of advice you can get, and it will be valuable to a large extent. On the other hand, there are a lot of clients that say, how do we do this quick and dirty? What's the best and fastest way into Canada? And that certainly there are reasons why that's a good approach in many cases as well. So let's stay closer to that side of the spectrum, okay?
Yep.
I like to tell clients there's 4 legs on the chair, okay? Here they are in a nutshell. We talked about a lot of them already. Number 1, corporate structure. How am I coming to Canada? What entity am I going to use? Is it my existing entity or a new one? And then that sort of has knock-on effects, as you mentioned, into the financial statements and the tax consequences. So number 1 is a corporate structure. Number 2, we talk about this as well, your intellectual property, your trademarks. Have you registered or applied for them already? You're already done that. You can probably check that one off your list. If you haven't, got to do some analysis about whether it's available, whether it can be used, and that sort of thing. So that's number 2 is the IP. Number 3 is your franchise agreement. So we haven't talked about this much yet, but for the most part, your franchise agreement can be used in Canada without a lot of changes. Of course, it needs to be amended in some sort of like details around the technical legal issues. And that's the job for the lawyer to do, to review that document top to bottom and as I call, Canadianize it. But I would tell you at the end of the day, 95% of that document can remain unchanged. So that's good for clients because it means an efficient, in terms of time and cost, process. It also means that you end up with a document that's very familiar to you and your salespeople without a lot of changes. That's number 3. Number 4 is the actual disclosure document itself. So the difference between 3 and 4 is 3, I'm talking about the contract, the franchise agreement, and number 4 is the actual FDD itself. We don't have item 1 through 23. What we do have, as I said before, is 6 separate provincial statutes. And what your lawyer should be doing in Canada is providing you with one format that provides compliance with all those 6 provinces at the same time. So you can use a one-size-fits-all approach wherever you may go in Canada. And that will, as I say, synthesize all the requirements from the 6 provinces at the same time. We will migrate a lot of the information from your US FTD into that format and then fill in the gaps and blanks with things that are unique to Canada with other information that needs to be obtained from the client through a process of asking some questions and maybe a meeting or two, just like we're having now over the phone or a video to pull out the rest of the information that's required for Canada. And that's it. Those are the 4 basics. Now that will set you up from a legal perspective. There are operational, marketing, supply chain issues that end up being legal issues too in some cases that are important as well. But if you really want to talk about the basic DNA of it, you have those 4 points, and that'll get you a long way to offering and awarding franchises in Canada.
Yeah, that's so on point. Frank, about how long does it take to get through that process?
I'll have it for you tomorrow morning.
No, look, there's a lot of clarity there. So,
I was being flippant and joking
no,
around.
I get it.
You told me to not be boring and make some jokes. So, clients, especially when they're being pulled into Canada, they're being pulled, and you want to make sure you meet the resistance on the other end of that pull. And the worst thing clients, where I know franchise brands suffer from, is having a slowdown in the document process that lets the lead jump off the line and go buy some other franchise instead. So, we're always aware, and I say this to clients all the time. Yes, I'm a franchise attorney, but I'm part of the franchise development team as well. And if you lose track of, making good on the things that your franchise salespeople say and on meeting the expectations of your prospective franchisees, and you can really impact the pace and the success of your franchise development pipeline. So we're aware of that all the time, and those are pressures that we have to address too. The reality, though, is that if we're going to set you up from nothing to offering franchises in Canada, it does take at the very least 3, 4, 5 weeks. If we're moving aggressively, it can take, and it has taken 3, 4, 5 months too at the same time, depending on what your franchise system is, how complicated it is, how much we get bogged down or the client gets bogged down on the corporate structure piece or whatever happens along the way and thinking some of these things through. But I have I've certainly had a situation where a client's being pulled aggressively, and they said to me, "We need this done in a matter of before the end of the month," and we've done that.
Right, and always there. I guess for me is what I don't, what we're not experts in, and what I can't control. I always worry about the accounting, right, and getting the right advice on those structures to make sure as we're going, and we could create the legal protection just to make sure there's everyone's informed and we're thinking through the accounting, tax, and structures on that end.
Right. Well, I'll just pick up on that. I mean, I'm a huge proponent, especially as being someone who often comes into the franchisor's orbit a little bit late, meaning they've already got you, Charles, or someone else working with them. I'm a big proponent of keeping people with the people they're familiar with. So I would never tell a client to go find a new accountant or someone else that they don't know if they have a trusting relationship with someone else. But the reality is that you need to have cross-border experience to provide the proper accounting advice, because as I mentioned, there are international tax issues that are arising when you are thinking about moving into another country. So you may have an accountant you've been using for 20 years who's served you perfectly well on domestic issues, but if they can't really advise you on how to get into Canada or out of the United States, you might be missing something. So what I can offer and do offer to clients is the other side of the puzzle, right? So you may have great domestic advice. You do need Canadian accounting advice too, or you need one advisor who can tackle both. But you definitely need to make sure that your systems are doing this, right? That they're connecting, the puzzle fits together in the right way, that it has to work from Canada, has to work from the US, and has to work together to make sure that that's set up in the right and the most efficient way for you as a franchisor.
Frank, as we, I mean, this is great advice, and the foundational items: corporate structure, trademarks, franchise agreement, disclosure document. Franchisors out there, just know we don't need registration in Canada. The process, it could take 4 weeks, 5 weeks, 6, but it's a fluid process. And Frank's provided some great insights on that. Frank, as we wrap this up, any like mistakes or pitfalls you see that are totally unnecessary, you wish more franchisors knew about it as they enter the Canadian market?
Yeah, absolutely. And I've seen it enough times, or I'm attuned to it enough that once we finish our disclosure documents with the clients, we'll spend some time on compliance, because I like to say to clients, as soon as the disclosure document is done, that's not the end of my work. That's actually the beginning of my work with you, because my job is not to just hand you a pile of paper and have you walk away. My job is to help you sell franchises and grow your franchise system and avoid the pitfalls that come your way. So I've certainly seen mistakes been made, and my experience in the many years I've been doing that is to try and identify them and have clients as they come to me avoid them. So the things that trip people up, mostly US franchisors into Canada, is to thinking that Canada is just one more state on the map, and to not identify and give enough respect really to the way that Canada and the law here differs. So 50,000 feet up in the air, it's exactly the same. Disclosure document, wait some time, then sign the franchise agreement. But there are definitely nuances in the things you can say and can't say to franchisees, in the flow, the timing of the way documents are given, the way that certain standards of what goes in or is not in the disclosure document. We don't really have time today to sort of dig into all of that. But I think what I'd like to leave your viewers with is the idea that yes, there is a significant amount of crossover and similarity with the documents and the process in Canada and the United States, but there needs to be enough respect given to the differences in the way that the laws are set up, that you do need to stop and you need to get educated, and you need to accept some training from someone who knows what they're doing in Canada to just smooth out the edges and identify some of those things that you could trip over, because they may seem small and trivial, but they're enough really to get some franchisors into real hot water, and they have in the past. I don't know if that's specific enough.
No, that's, I mean, I think as we all get older, we realize like you need to lean on people that've been there before. And it's not to say, hey, just work with a lawyer. Franchisors, I think, are smart enough to know. I mean, Canada is an important market, and you need to build up that team with not only your Canadian FDD, but your Canadian IQ in terms of the franchise marketplace and really how to build up your franchise sales platform in Canada. So I think that's helpful.
Yeah, and it's outside of that, in terms of just like operations, some of the things that I see that are sometimes not done well or not done at the right time or in the right way is your operations manual. It is not a legal document, but we all know it's essential to your franchise system. And so, I have seen the manual not updated at all to accommodate or address unique things in the Canadian market. That becomes an operational problem if a franchisee opens it up and can't find the answer to X, Y, and Z operating method or something of that nature. But it can also become a legal issue if your franchise agreement, and we all know this, says 100 times as set out in the operations manual. If it's not set out properly in the operations manual, you now have a problem operating, but you may also have a gap in the way you've prepared your franchise documents. Other things I see are, more on the supply chain. If you're a restaurant or a food, in the food business, or you otherwise have, an important supply concept to your franchise system, it should not be taken for granted that you can just use the same supply chain or network or suppliers in Canada. There are even trade restrictions on moving certain goods and products over the borders. Like if you think you're going to move dairy products or meat proteins over the border, and in the same way that you move those between states, you're not right about that at all. It becomes economically challenging to do that. There are customs and tariffs on doing that, and a whole bunch of other things moving product over an international border. So in some cases, it becomes important or even a necessity to set up a domestic supply chain in Canada. And the economics of that then change the way your franchise systems may work, because you may not have the same benefit of scale, the same rebate program. So supply chain is obviously fundamental to a franchise system, and it needs to be reviewed and thought through for sure. And that's one of the things I think that you can trip over if you're pulled into Canada. If you don't think that through and you don't build enough time to build out your, the basics of your economic model and your supply model, those are things that can confront you urgently at the wrong time once you have franchisees operating, and then you're in a bit more of a problem if you haven't built enough of a timeline and system to do that in a timely way.
Yeah, and I think your point about the operations manual, it seems obvious, but that is such a critical issue. And I'd love to say that was at the top of my list when we started this conversation, but it wasn't, and it will be in the future. Frank, I appreciate that. I appreciate your insights, and look forward to talking more about Canadian expansion.
Well, thanks for having me. I really appreciate it. It's a topic I talk about every day, so I'm happy to be able to share with you and your viewers. And if there's questions or an opportunity for us to have another conversation at some other point in time, I'd be happy to do that as well.
Thanks, Frank.